2021. Hopefully by then, all of this will have blown over. And with that, I will turn it over to our speaker, Josh Blackman. He has been a guest of ours several times. He's a great speaker. He's a tenured professor at the South Texas School of Law. He's authored numerous books, and his latest book, which I'll do a cheap plug for, and he'll talk about more, is 100 Supreme Court Cases Everyone Should. So with that, he's got one too. I will turn it over to Professor Josh Blackman.
Thank you so much. You know, I was supposed to be in Chicago today, but that wasn't going to happen. So I'm grateful we could do this over Zoom. The topic for today is Corona and the Constitution. But I want to start with some fun. I want to do a bit of an icebreaker. And I want to play a game, if I can, of Supreme Court Jeopardy. Okay? But there's prizes attached to this game. We have copies of my book in Chicago. We had actually sent 10 copies of the book to Chicago to distribute to all of you at this meeting, but we can't. So here's the deal. I'm going to ask 10 questions. And if you get a question right, you get a free book. You can pick the books up from Ryan or pick them up at the next meeting whenever that's scheduled. So we'll do this, of course, Zoom style. By the way, could we do it? We are going to ask questions, and you can raise your hand. If you see in the Zoom interface, there's a button that says raise hand. If you click that, I can call on you, and I'll allow you to talk, to say the right answer. Okay, everyone understand? And I see that the chat is disabled. You won't need the chat. Okay. All right. So let's just do a test run. Can everyone just click the raise hand button so I can see that this feature is working for everyone? Okay. Perfect. All of you did it. Beautiful. Okay. I'm going to lower all of your hands. Okay. So the way it'll work is I'll show a question, and whoever first to raise their hand, I'll call on. All right, let's see how this works. Question number 1. He was the only president to serve a full 4-year term without nominating a Supreme Court justice. Okay? He was the only president to serve a full 4-year term without nominating a Supreme Court justice. Okay, the first hand up is Rick. Rick, what's your answer here?
Jimmy Carter.
That is correct. Excellent. Who is Jimmy Carter? The Georgians served 4 years and thankfully made zero, sorry, a little editorializing, Trebek never does that, and made 0 appointments to the Supreme Court. There are 3 other presidents who made 0 appointments, but they didn't serve full terms. You have William Henry Harrison, Zachary Taylor, and of course, Andrew Johnson. Okay? All right. Very good. Thanks, Rick. And make sure you get a book from Ryan after this is all over. Okay. And if you got a question right, don't buzz in again. Let other people try and get the questions right. Okay. Thank you. All right. Question number 2. Ready? I'm going to lower all the hands. Okay. Question number 2. William Howard Taft is the only person who served as both President of the United States and Chief Justice of the United States. But this former presidential candidate who lost an election replaced Taft on the Supreme Court. Again, the question is, William Howard Taft is the only person who served as both President of the United States and Chief Justice of the United States. This former presidential candidate who lost the election replaced Taft on the Supreme Court. Okay, I see Richard Benson. Go for it, Richard.
All right. It's probably wrong, but Holmes?
No, it's not Holmes. Holmes was never a presidential candidate.
Okay.
All right. Who else? He replaced Taft on the Supreme Court. I'll give you a hint. Oh, Pat?
Charles Evans Hughes.
That is correct. Charles Evans Hughes was the governor of New York, Republican. He resigned from the court to run against Woodrow Wilson. He lost. But then Hughes was later put on the Supreme Court as Chief Justice. So correct, Pat, number 2. Good job. All right. We're ready for question number 3. Ooh. Okay. We'll lower all the hands. Here's your question. At the age of 32, this Harvard University professor became the youngest ever Associate Justice of the Supreme Court. At the age of 32, this Harvard professor became the youngest ever Associate Justice of the Supreme Court. I see Patrick Callahan.
Joseph Story.
Joseph Story is correct. He was a professor at the age of 27. And James Madison appointed him to the court 5 years later. We are all slacking big time. Supreme Court by 32. I think Trump puts him on young. This is even younger. All right. Thank you, Pat. So we have so far 4 winners. Very good so far. Ready for question 4? This is fun. Okay. This Civil War veteran who retired at the age of 90 was the oldest active Supreme Court justice. This Civil War veteran who retired at the age of 90 was the oldest active Supreme Court justice. Okay, I see Clyde Taylor is the first hand up. Go ahead, Clyde.
Oliver Wendell Holmes?
Exactly. Thank you so much. Perfect answer. Oliver Wendell Holmes. He's a remarkable guy. He was shot twice during the Civil War, survived both shots. TR put him on the Supreme Court at the age of 61, and he served for 29 years. Remarkable career. All right, well, good job, Clyde. Okay, we're about halfway done. Question 5.
What are you guys doing?
What's that? I hear a voice. All right, keep going. Okay, so this one requires 2 names. In 1969, this outgoing Chief Justice issued the oath of office to this incoming Chief Justice. Again, the question is, in 1969, this outgoing Chief Justice issued the oath of office to this incoming Chief Justice. Okay, Mark, I see your hands up. Go for it. Mark? You there, Mark? Oh, your hand was up. Oh.
Can you hear me now?
Yeah, I got you. Come on in.
Okay, the outgoing Chief Justice was Earl Warren. The incoming Chief Justice was Warren Burger.
Perfect. Exactly right. The outgoing was Earl Warren, and the incoming was Chief Justice Warren Burger. They share the name Warren in that funny way. This was actually a unique occurrence. All previous Chief Justices had died in office. Warren was the first one to actually retire, so he was able to swear in his predecessor. Indeed, more recently, Chief Justice Rehnquist died a few months before Chief Justice Roberts was confirmed. Okay, so far we got 5 winners. Good job, everyone. Question number 6. This one's a little trickier, but there's a hint in there. This justice, who was related through marriage to Francis Scott Key, was the first Catholic appointed to the Supreme Court. This justice, who was related through marriage to Francis Scott Key, was the first Catholic appointed to the Supreme Court. Okay, we got Bill Crease. Yes, Bill.
Taney.
Tawney, exactly right.
Tawney.
Yep, close enough. Yeah, it's pronounced Tawney. Chief Justice Roger Burke Tawney, who is not a well-liked justice today, at least, was the first Catholic on the court. And he was from Baltimore, and he married Anne Key, who was a sister of the author of the Star Spangled Banner, Francis Scott Key. Okay, fun fact. All right. Good job, Bill. Okay. The next question, number 7. Again, this one asks for the name of 2 people. These 2 Chief Justices appeared on U.S. currency. These 2 Chief Justices appeared.
Salmon P. Chase was on 10,000.
Oh, sorry, Bill. I hear you talking out loud, helping people. Appeared on U.S. currency. I'm looking for 2 names. Come on, one of the people hasn't buzzed in yet. Still got questions left. Okay, we got a question answered. Pat, go for it.
John Marshall and John Jay?
You are half right. I won't say which half.
Fair enough.
Okay. Richard Benson.
Marshall and Taft?
Not correct.
Ah, okay, well, that helps. John Jay was the right one.
No, I didn't say that. Copeland, Trevor. You there, Trevor?
I had to confirm the unmute. Yes. So Chase and Marshall.
Yes, that's correct.
Salmon P.
Justice.
Chase, right?
Exactly. Chief Justice Marshall was in the $500 bill, and Chief Justice Chase was on the $10,000 bill. What kind of inflation is that? We probably need those bills nowadays. We've Venezuela soon, right? $10,000. Chase was also the Secretary of the Treasury, and in that role, he was actually on the first piece of U.S. currency, but it was not his capacity as Chief Justice. Okay. Almost done. It's going better than I thought. Question number 8. This is a hard one. So he said, well, you know the convention. This native of Scotland, who represented Pennsylvania during the Constitutional Convention, became the first fully vested member of the Supreme Court on October 5th, 1789. This is a hard one. This native of Scotland, who represented Pennsylvania during the Constitutional Convention, became the first fully vested member of the Supreme Court on October 5th, 1789. Ooh, rack your brains. This one's tricky. No? I see Mark has a hand up. He's a repeat. If no one else, I'll go back to him. I was worried this would happen with this question. Give me a little bit too hard. All right, Mark, what do you think?
John Dickinson.
No, he's from Pennsylvania, but not the person I'm thinking of.
Ooh.
Okay. I'll give you a hint. He shares the name with a president. His last name, he shares a name with a president. I'm not seeing any hands. I'm grateful no one's cheating. All right, we'll pass on this one. The answer is James Wilson. He was a Scot and probably one of those underrated framers at the convention. Very influential person. He was President Washington's first nominee to the Supreme Court. He's also the first justice to die in office. He had a stroke about 9 years later. All right, the last one I think might take a couple guesses. Richard, is that a hand?
Nope, sorry.
Errant hand. You know, it's like when you're in class. Sorry, I was just stretching, right? You know. All right, number 9. See how well you know your Supreme Court justices. During the 1930s, these 4 conservative justices, known as the 4 Horsemen, voted as a bloc to declare unconstitutional progressive legislation. During the 1930s, these 4 conservative justices, known as the 4 Horsemen, voted as a bloc to declare unconstitutional progressive legislation. Made them hard at the end on purpose. Anyone? Okay. Mark, what do you think?
Willis Van Devanter, James McReynolds, Pierce Butler, and George Sutherland.
Nailed it. 4 for 4. Perfect. I think you got them in order also. Oh, almost order. Perfect. So these were the 4 justices who consistently declared federal laws unconstitutional. These were the OGs, right? James McReynolds, Wikipedia. James McReynolds, Willis Van Devanter, George Sutherland, and Pierce Butler. McReynolds had the longest tenure. All right. Thank you for that. And last question. This one might take a few guesses. Okay. Question number 10. President Washington holds a record with 11 Supreme Court appointments. President Roosevelt is in second place with this number of appointments. I'm looking for a number here. Okay. Christine, what's your guess? Don't hear you yet. You there, Christine? It's not working. I'm sorry, Christine. Hold on. Let's try some more time. Okay. You there, Christine?
Am I here now?
Yes. What's your number? I hear you.
I just guessed 4.
4 is not correct. And I'll tell you the number is higher than 4. Okay. I see next is L. Scary. I'm not sure who that is. Okay. L. Scary. What's your number?
Can you hear me?
Yep.
8.
Close.
Oof.
Not 8. Who else? Someone who hasn't raised their hand before. Okay, Peter.
9.
9. Bingo. Winner. Right there. I knew that'd be process of elimination. That's why I put this one last. So here are the 9. Hugo Black in 37. Stanley Reed in 38. Frankfurter in 39. Douglas in 39. Murphy in 1940. He appointed Chief Justice Stone in 41. Stone was an associate justice. Roosevelt upgraded him. Jimmy Burns in 41. Robert H. Jackson in 1941. And Wiley Rutledge in 43. All right, I think we got 9 winners. And I'll tell you what, if you guys ever have a live event again and your mayor and government let you, I'll be happy to come back and sign all the books for you, and maybe give some books to other people. All right, that one actually went pretty well. I thought that first time I've done this, but I think that went pretty well. All right, enough for the stupid screen sharing. Now let's get to business. Let me put everyone on mute first before we lose my way. Sorry. Okay, everyone's on mute. Okay. The topic today is about the Constitution and the coronavirus. Now, if you'd asked me like 4 months ago about the Constitution and the coronavirus, I thought, I don't know. What difference does it make? You know, I haven't thought about it. But in the span of a very short time, both the state and federal government made stunning decisions based on very little knowledge with almost no understanding of what would and would not work. So now we are more or less, call it 2 months from when this thing exploded. And we can look at this situation with a little bit of clarity, with a little bit of hindsight, which is always 20/20. I want to talk about 6 major areas where we've seen sudden shifts in the law. The first is the free exercise of religion. The second is the freedom of speech and freedom of association. The third concerns the Second Amendment, the right to bear arms. Fourth, we'll talk about abortion, right? What Fed's event will be complete without abortion, talking. Next, I want to talk about voting rights. We've seen a lot of that, especially in your neighbors to the west, I suppose, in Wisconsin. And finally, talk a little bit of federalism and the separation of what the federal government should do and what the state government should do. So let's start with religion. Now, this is a area of law that's very much in flux. In fact, an Illinois church filed an emergency application last night, I think, with the Supreme Court to challenge Governor, was it Pritzker? Yeah, Pritzker's a shutdown order. So let me just give some background that you probably remember from law school or wherever else you studied. As a general matter, the government can't target religion for hostile treatment, right? When the government targets religion for hostile treatment, courts are very skeptical. Courts review those laws with what's called strict scrutiny. And generally with strict scrutiny, the government will lose because there's not a good enough justification to justify that targeting. But what about where the government is neutral towards religion, right? That they have a policy that applies equally to people of different faiths. In those cases with laws of what are called general applicability, the courts are not so skeptical. And the courts review those laws with what's known as rational basis review, which means so long as the government has some rational basis, the action is lawful. So how do we understand the religious aspect of these corona orders? Well, let's get some basic facts out. Shortly after the coronavirus blew up, governors and mayors in every state in the country issued shutdown orders. They said, all businesses are shut down except ... right? They said all non-essential businesses are shut down, but essential businesses can stay open. So you may ask, well, Josh, what's an essential business, right? What separates an essential from a non-essential business? And this is a very important issue. In different states, governors have different definitions of what's essential. In Illinois and some blue states, houses of worship were not considered essential. In Texas, where I live, houses of worship were considered essential. This initial distinction really is significant because historically the courts have been deferential to the government when they say, here's what's needed and here's what's not during a crisis. Okay? So then we have the initial decisions of the governors. Your governor said churches are not essential. And then we go to litigation, right? And we ask with the First Amendment Free Exercise Clause, are these laws targeting religion, right? In other words, did the government of Illinois single out houses of worship for unfair treatment? The governor says, of course not, right? We've deemed a lot of places non-essential, not just houses of worship. Therefore, we're not treating religion differently from non-religion. This is basically what the Seventh Circuit said about 2 weeks ago in a decision involving a Romanian Pentecostal church from Illinois. Now, not all the courts have come out this way. The Seventh Circuit and the Ninth Circuit ruled in favor of the shutdown orders, but the Sixth Circuit and the Fifth Circuit ruled in favor of the houses of worship. And let me explain to you the distinction. What happens when a law has lots of exceptions? We say, well, only essential businesses can open, but here's this long list of essential businesses. Liquor stores, for example, right? You need a liquor store during a crisis. Car mechanics, law firms, right? The lawyers need to be in their offices. Every manner of business in which people assemble is allowed to stay open. But a house of worship in which people are assembling cannot. At what point does a law of general applicability become so riddled by exceptions that's no longer generally applicable, right? At what point do we say this law isn't actually designed to protect public safety, but it's based on a judgment that religion isn't essential, right? At what point do we say that the sorts of carve-outs here recognize that some people are safe to be put together, but not people of faith, right? Even if the church promises to have social distancing, space people out, wear facial coverings, right? And they still can't assemble. At what point do we say that maybe the government here isn't neutral towards religion? Maybe they think people of faith can't be trusted, that they're going to break the rules, that they're going to take their masks off, that they're going to engage in their rituals in an unsafe fashion. And once you recognize that perhaps the governors of some of these blue states do have this sort of negative perception of religious people, the First Amendment analysis changes. We're no longer dealing with neutral laws. At that point, we're dealing with laws that reflect a skepticism of religion. I think the best decision on this topic came from the Sixth Circuit. The panel it was with Judges Sutton, McKeague, and Nalbandian. But I can tell you that Judge Sutton wrote this opinion. It's damn good. Judge Sutton's a favorite judge of mine, most of the time at least. But he writes very, very well. I want to read you just a sentence from the court's opinion. Judge Sutton draws a distinction between life-sustaining measures and soul-sustaining measures, right? In other words, the state exempted from their orders law firms, laundromats, liquor stores, and gun shops to continue to operate, but they do not permit soul-sustaining groups like houses of worship, right? Why can some people meet in groups with social distancing, but others can't? Generally, the government can draw these sorts of lines. When the case involves worship, we're in a very different situation. Judge Sutton writes, why is it safe to wait in a car for a liquor store to open, but dangerous to wait in a car to hear morning prayers? Why can someone safely walk down a grocery store aisle, but not a pew? And why can someone safely interact with a brave delivery woman, but not with a stoic minister? The state has no good answers. Judge Sutton tells us, while the law may take periodic naps during a pandemic, we will not let it sleep through one. He adds, the governor has offered no good reason so far for refusing to trust the congregants who promise to use care and worship in just the same way he trusts accountants, lawyers, and laundromat workers to do the same. In other words, at some point, buried deep in the governor's mind, he says, well, people at liquor stores can be trusted to practice social distancing, but not people in the Romanian Pentecostal church. They can't be trusted, right? We think they're going to be so motivated by religious fervor that they'll screw up. And we have to take this prophylactic step in advance to stop them. That does not work under the Free Exercise Clause. That does not work. But even, let's take a step back. We've seen some stunning videos. There was one video in Italy that really grabbed my attention, where a police officer walked into a mass, a Catholic mass in Italy, and he ordered the priest to stop his service. And you know what the priest told him? All right, I'll pay the fine. My kind of guy. This was being live streamed, by the way. The priest replies that you can just give parishioners the communion by Zoom, right? Give them a Skype Zoom. I don't know if that works. You throw it on the screen or something. And the priest refused to leave. Eventually, he finished the service, but I'm stunned at how quickly people have been willing to just suspend millennia-old traditions. We're talking thousands of years, these traditions. These are old traditions, and just suspend them at the drop of the hat. Now, I don't want to make light of the fact that people have gotten sick of churches. I think what these churches are asking for is to assemble under the same exact conditions that other groups are allowed to meet, with masks and distancing and cleaning touch points, all these other things which we have to now do with our lives, right? Putting a plexiglass box around the priest. I don't know. Wait till we go to law school with plexiglass containers. We like at the post office. That's where we're headed, I think. Okay. All right. So that's the first issue with religion. What's the court going to do here? I'll tell you, I think the court may actually intervene. I don't know if there are 5 votes or probably 4. Of course, everything comes down to what Roberts wants to do. But I think Roberts may actually say that some of these policies have so many exceptions that they may not be motivated by neutrality anymore. And we're also now 3 months into this sort of epidemic. We know more now than we did before. And I think a lot of these sort of shutdown orders, complete shutdown orders, have outlived their usefulness. So long as these churches have distancing, I don't see a good reason to keep them apart, short of saying we don't trust people of faith to follow the rules. And if that's the justification, that doesn't fly with the First Amendment. All right. I'll take questions at the end, I promise. The next topic is freedom of speech and freedom of association. No, I'm not talking about Twitter. Maybe that'll be for another talk. President's executive order, whatever. But I want to talk about protesting in public. There's something special about protesting in public, right? We can all, distribute flyers, we can write blog posts, we can tweet, but there's something really intrinsic about being in person, standing in front of, the state capitol or city hall and protesting. But one of the things that happened after Corona is protests were basically banned. For some period of time, the police would arrest anyone who simply assembled, even if they're being perfectly calm and orderly. And the argument was your mere presence here is a danger, right? Remember the phrase clear and present danger? Merely being present was the danger. And I think people accepted these sorts of rulings without much thought, but we had massive deprivations of free speech. Now, a lot of these protesters like to have AR-15s in their backs. We saw this in Michigan. I think the Michigan legislature basically suspended their session to avoid having people march with their ARs in their back. Okay. You may not like people open carry. I'm not a fan of it myself, but people do have the right to peacefully protest. And this was a right that was very quickly infringed without much consideration. Let's move on from the First Amendment to the Second Amendment. Almost immediately after states issued their shutdown orders, lots of businesses were exempted. But what businesses were not exempted? Firearm stores. In almost every state, to buy a gun, you need to go to a store. I don't think Chicago has gun shows, and we have them here in Texas, but in most states, you need to go to a gun store. You can't order a gun online. You have to go to a store, drop off paperwork, and meet with someone to physically hand over the weapon. They don't put this in the mail. But when the state determines that a gun store is non-essential, it becomes impossible to acquire a gun. You might ask, does the right to bear arms include the right to acquire arms? I think it does. How are you going to get a gun if you don't buy it, right? Several states initially banned gun stores, but then they got spooked out when those cases may have gone to the Supreme Court, and they actually repealed their policies. So Pennsylvania, this is my favorite. Initially, Pennsylvania had a definition of essential businesses. What was essential? The marshmallow factory that made Peeps, those little Easter marshmallow candies, that was considered essential because we were right on the doorsteps of Easter. But gun stores, an actual constitutional right, were considered non-essential. The governor of Pennsylvania blinked and he repealed that policy. New Jersey, however, is still defending their closure of gun stores. Other states deemed firing ranges to be non-essential. Well, to have a gun, you need to be able to use it safely. All right. None of those cases made to the Supreme Court. I think the gun control people were freaked out that the plaintiffs may actually win. So they would try and settle it and change their policy, and then it makes it unappealing to the Supreme Court, right? I mean, the current strategy for the anti-gun people is to basically kick the can and keep away all the cases from the Supreme Court. Whatever you can, don't let them decide a case. All right. The next topic, moving from the Second Amendment to the 14th Amendment, is abortion. This is how it works. Blue states try to regulate guns, and red states try to regulate abortion. I mean, this is the world we live in. Shortly after the corona outbreak, a number of conservative states issued policies prohibiting elective surgery. So if you needed, I don't know, like a colonoscopy, right? Or you needed to have some, non-urgent procedure, dental work perhaps, or maybe you want to get a nose job. I don't know what people get nowadays, right? States put on hold all elective surgery. And the justification was we need to preserve PPE, that is personal protective equipment. Remember the N95 mask we were all fighting over, toilet paper, whatever. We need these supplies quite urgently. And we don't want people using supplies for non-essential surgery. Well, what did Texas say was not essential? Abortion, right? And the argument was, well, you can have the abortion later. You don't have to have it right now. You have up to a certain number of weeks to have it. As you can imagine, Planned Parenthood and other groups sued, arguing this violates the 14th Amendment. The litigation was messy and complicated, but the long and short of it is that the Fifth Circuit held that some forms of abortion were permitted, right? Let's say someone was fairly late in a pregnancy, and if they waited longer, an abortion would become illegal. For those people, they would be able to get it. What about people who are early on in the pregnancy and can, in theory, wait a few weeks? The court said that a delay of a few weeks until this epidemic perhaps subsides was permissible. And that's now a Fifth Circuit precedent. That's quite significant. And that precedent relied on a case called Jacobson versus Massachusetts. It was a Massachusetts case from 1905, an old case. And Jacobson involved the right of forcible vaccinations. The court held that, yes, you can force someone to be vaccinated, even though it's jamming a needle in their arm or whatever else method they use. I think if and when we get a vaccine, we'll see a lot of people freak out with mandatory vaccinations and Bill Gates and microchips and everything else. But that's where we're headed. All right, so those are the abortion cases. Let's talk about voting for a minute. The courts have held to varying degrees that the Constitution protects the right to vote. And things that burden the right to vote might be unconstitutional. I say might because the law here is very squishy. There's really not a clear test about when voting rights are violated. When there's racial discrimination, perhaps you have some more clarity. But let's talk about Corona, right? In Wisconsin, you had this contested election for the Supreme Court of the state. It was very contested. The election happened shortly after the outbreak of this disease. A federal judge in Wisconsin ordered that you would expand the amount of time to return mail-in ballots. This case went to the U.S. Supreme Court. The Supreme Court said, no, you can't do this. You have to give people more. You can't give people more time. The law doesn't permit it. The dissenter said, oh my God, this is worse than the world. People are going to die. Turns out it wasn't the end of the world. In fact, more people voted than they thought would vote. So a lot of these sort of doom and gloom projections simply are never true. I think they're used just to hype things up. But you can see people are waiting in line with masks on, and this is somewhat of a scary sight. In an ideal world, the legislature would be the ones to decide what the voting rules are. But in our gridlock government, Wisconsin in particular, there's no compromise. So unfortunately, it goes to the courts. More recently, in my home state of Texas, we had a case involving vote by mail. The statute says that you can get an absentee ballot if you have a disability. Okay. Various Democratic groups sued, and they argued that a disability is being susceptible to corona. That is, if you are susceptible to corona, you have a disability. Everyone has a disability, right? We all are susceptible to corona. The Texas Supreme Court rejected that by a vote of 9-0 and said that doesn't work, right? That does not work. You can't give an absentee ballot to every single person in the state who can vote. We're going to see a lot more litigation and this will head to the Supreme Court, and it's going to make people very angry. I don't take a strong position on election law. It's not my expertise, but the court's going to have to resolve a lot of really messy issues. Okay. Last point, I'll go to some Q&A. People raise their hands. I'm sorry the chat's not working. We'll get that straightened out for next time. Let's talk about federalism. Thank God for federalism. I'm actually grateful for it. The federal government does not have the power to order the states what to do. Indeed, the federal government should not be in the lead telling states what to do. The states historically have had primary responsibility for the health and safety of their people, as it should be. Very often, President Trump says, I'm going to order the states to do X. And I say, huh? You can't do that. That's not for the president to do. And in fact, liberal states are quite happy that President Trump can't order them around. But the downside is you now have a patchwork system with different states taking different approaches. Texas is open for business. Illinois is still shut down. Frustrating as it may be, I think that's generally how things should work. I don't think the federal government should be in charge. I think states should have more flexibility. But we've just become so accustomed as a culture to demanding answers from the state, and demanding answers from Washington, that there's something refreshing of actually seeing governors in charge and trying to do things for to protect and secure their people. So I think federalism has worked itself pretty pure during this entire crisis. Okay, I have 7:15. I will stop here and be happy to call on questions from anyone. Just click the raise hand button and I'll be happy to call on you so you can ask your question. If you want to put your camera on as well and show yourself to the world, you can, but no pressure. Okay. Questions? Okay. Yes. Bill, go ahead. And I understand the chats are now open as well. Okay, Bill, can you hear us?
Yes, I hear you.
Okay. What's the question?
I'm sorry, I don't have a question. I hit the raise hand mistakenly.
Okay.
Just like many of my students do.
Yeah, they're just raising their, stretching. All right, thanks, Bill.
Okay, sorry.
Clyde, yes, sir. Yeah. I'm sorry, Clyde. Just take it off mute, please.
Yep, can you hear me?
Yep, loud and clear.
Yeah, so I guess another area of lawsuits have been like basically kind of balance of powers, administrative law challenges that, ex-governor has, like in Illinois, the law says, okay, he can declare an emergency for 30 days, then he's done, but then he declares another emergency for another 30 days.
Yeah.
And the law allow that, maybe not. So that's another area of lawsuits that have been out there, and maybe they're each different, but what's your take on that? Is that, do you see any sort of like chance of success there?
Very good. Thank you so much, Clyde. The short answer is state administrative law is very important, right? We always think about federal administrative law. No, state law is very important. Governors don't have inherent powers, right? They only have the powers given to them by the legislature. And very often, a lot of these shutdown orders are taking very mundane statutes and stretching them to unfathomable stretch, right? The idea that a statute that says you can regulate in the public interest lets you shut down every business in the state for, 3 months? It's insane. These are issues that the legislature should be resolving. And I hope that courts can recognize this. We saw in Wisconsin, the Supreme Court decision that said the governor lacked this power. It wasn't a ruling on the federal constitution. It was actually pretty narrow, but it became a very partisan issue, which is unfortunate. But I do think that state common law and state administrative law is significant. Perhaps legislatures should take this opportunity to revise their statute books and give guidance for how and when shutdowns can occur. We'll have this again happening for sure. But just relying on, a statute to deal with a smallpox outbreak that affects a few dozen people is not sufficient to deal with a statewide closure mandate. Okay, but thank you for that question, Clyde. Next question, please raise your hand. And Cecilia, thank you for that kind comment in the chat. I appreciate it. Super good talk. I'll take it. Other questions? It's about 80 degrees outside here. Okay. All right, Peter, go ahead. I think you're on mute, Peter.
Yeah, during the early on in the pandemic, I read about how Governor Cuomo used the state guard to seize ventilators from private businesses, and I saw they cited eminent domain. Do you think that holds up in court?
Yeah, thank you so much for that question. We saw some crazy stuff, right? We saw some crazy stuff. My favorite was when the governor of Rhode Island ordered her state troopers to stop at the border cars with New York license plates. Let me say it again. The governor of Rhode Island ordered her troopers to stop New York cars from entering the state. That's insane, right? I mean, can you just fathom how nuts that is? The governor of New York actually ordered people to relinquish ventilators, because apparently we needed ventilators. We didn't really need them. They're apparently not that helpful, right? Is that a taking? I think it is. There have been lots of taking orders for regulatory takings, that you shut down my business, but the government literally seizes your stuff. They have to pay you for it. They can't just, when a police officer commits a crime, it's a crime, right? They can't just come and take your stuff. They have to pay you for it. Maybe they'll give you a receipt and send you a check in a few months. But we saw crazy things. My favorite was the governor of, I think it was Maryland, Hogan, used the National Guard to protect the stock of equipment from being seized by the feds. Right, there were the federal government would take their stuff, so they actually were using state troops to do this. I mean, this is like Civil War stuff. I'm not being facetious. That states fighting each other and using their troops to secure goods. I mean, this is stunning stuff that happened without very little thought. People say, all right, whatever, we have Corona to stop it. Amazing. Okay, thank you, Peter, for that. Other questions? L. Scary writes, Mr. Blackman, excellent presentation. It is nice to know that we weren't all crazy by objecting to whatever happened to our constitutional rights. Yeah, thanks. No, I mean, you guys aren't nuts. Whenever the government tries to keep you safe, they always err on the side of caution, right? It's hard for politicians to say, you know what, we should do less, right? Let's err on the side of liberty instead of the side of caution. Very hard for politicians to say that. They usually get ridiculed, but sometimes that's the right judgment to make. Other questions, please hit the raise hand button if you have a question. I'd be happy to call on you. Oh, I'm sorry, the questions in the Q&A, I wasn't looking at those. My apologies. Okay, so Pat asks, what are your thoughts about the contract clause as it applies to state proposals to retroactively amend policies of insurance to provide business interruption coverage? So let me just rephrase Pat's question. A lot of insurance policies are probably written in such a way that either do or do not cover corona-related ailments. And can the state retroactively amend policies to provide business interruption coverage? The contracts clause was a very important part of the Constitution for a very long time. And the Supreme Court in the 30s said, nah, never mind, doesn't really mean anything. So I think you're not going to get much juice out of a contracts clause challenge. Pat also asks, was the law as it applies to governors restricting travel into their states from other states? Man, what a question. Generally, governors can't impose travel barriers. There's something called the Privileges and Immunities Clause, right, which has so-called right of travel. All that stuff was unconstitutional. But I think the courts were just freaking out and they were afraid of stopping because in the middle of a pandemic. Okay, we have a question in the queue from our friend Trevor. Go ahead.
So you made reference to, especially with the Religious Freedom Employment Division v. Smith precedents, and how this came out in a couple of different circuits. if, as seems to be likely, some states keep rolling limitations forward, and you get more and different disparate opinions either in adjacent states or within the same circuit or across different circuits, at some point, do you get a potential 14th Amendment basis for a suit? And is that something that an individual would successfully be able to raise, or would you have to have a group, or a class probably wouldn't make it just because the whole thing would go away before then?
Just to be clear, are you asking a 14th Amendment equal protection? Which amendment? Which
Oh,
clause?
14th Amendment equal protection. So, I mean, you have, let's say you've got people in Illinois who are facing certain restrictions. People in Indiana are not. They live 10 miles away from each other on side of, I mean, if it's my church building is on this side of the border, I can't do X. If it's on the other side of the border, those people can. And so you kind of say, even though you have states within the same circuit actually, imposing these kinds of restrictions, is there an equal protection argument, or would we just be sort of on a case-by-case basis under Smith?
Yeah, I think that's a good question. I would actually frame it a little bit differently as due process. That base becomes irrational, right? Why is, a city, Kansas City, Missouri one way and Kansas City, Kansas another way, right? It's a city on the border, right? How is it that the epidemic is so much different in, a couple miles across, that you have to have this completely draconian scheme? Look, I think there might be 4 votes in the Supreme Court to reverse employment division versus Smith. That was a case you referenced. I don't know that Roberts is there because he's Roberts, but I think at a minimum, you might have a willingness to say that this is not neutral. This is actually hostile. In fact, we saw that in the Masterpiece Cake Shop case a few years ago, where you had the state basically going after this one bake shop that wouldn't make cakes for gay weddings, but other businesses were not treated in this fashion. So I think the sort of disparate treatment will be the way the court latches on. The fact that state A does it one way and state B does another way, I think is tricky. But good question, Trevor. Appreciate it. Thank you. Okay, other questions, please. We have a couple minutes left. I'll let you out here at 7:30. Any other questions? Please click the raise hand. Oh, I think I see something in the, okay. We have Clyde. Yes, Clyde, go ahead. And I got 2 questions in the queue from Peter and Alex. Clyde, go ahead.
Quick. I mean, do you have any sense that like lobbyists affected kind of how these shutdown orders were written? And if so, kind of what does that say about the legality and, general applicability nature of them, and is that a grounds for suit?
Well, look, I mean, a lot of these orders were drafted in a very, how do I put it, haphazard fashion. I don't think there was much thought put into them. They were done very quickly. I'm not familiar with what lobbyists actually did, to be frank. I think at some point the governors will start modifying their policies when they're afraid the Supreme Court will rule against them. So, for example, California and San Diego County were trying to basically block a church from opening up, and an appeal was filed to the Supreme Court. And like the next day, California said, never mind, we're changing our policy. So I think they're just going to try to play keep away. But good question. Peter, oh boy, we got a question about the Logan Act. Peter asked, I've noticed that some governors, like the governor of Maryland, are directly negotiating with the president of Korea for supplies. Are state governors allowed to negotiate deals with foreign heads of state? No. In fact, the Constitution says that states cannot make treaties with foreign governments, right? They can't. They need the consent of Congress to do that. They can't do it on their own. We saw this last year where California made basically an agreement with, I think, Canada to try to restrict climate change and greenhouse gases. I think there's a good argument that those are illegal. The second part of your question asked about the Logan Act. This is the worst law in the U.S. Code. It's this old statute from the 1790s that prevents the state governments, that prevents people from interfering with foreign relations. This law is largely a dead letter. All right. Alex asks, here in Canada, liquor stores are required to be open for alcoholics who might die from withdrawal. Delivery services are required for food. Grocery stores are high risk, but they're open. Okay. Okay. Very good. I think I see your point. Okay. He writes, your beliefs and rights are protected until you start to willfully harm others. I think that's generally how people try to approach it. But the question is, can these churches open without harming others? And I think if some businesses can, others can as well. All right, maybe one more question from the queue. Anyone else? Going once. Oh, I see a hand up. Ryan, go ahead. Yes, I'll come back to you.
I didn't want to hog the time here anymore. But I guess
Turn your camera back on so we can see.
Okay, there we go. You might have my assistant joining here. My dog is barking. I was just wondering if you could comment on liability protection. I think some senators have been talking about it. What would that look like? And if it doesn't get included in another bill, are those suits going to be successful against businesses, sports teams, et cetera?
Right. So let me answer Ryan's question. When you talk about federal liability protection, you're talking about what's called preemption, right? Where basically a federal law would preempt every conceivable local tort. So let's say someone walks into a Walmart in Chicago, a Costco in Chicago, and contracts corona, right? Can they sue Walmart under some sort of state negligence theory, right? How do you know someone attracted corona in the Walmart? Maybe they got it, at Sam's Club. Maybe they got it, at Kroger, wherever else. So the thinking is you need a single federal policy to block all tort suits. These sorts of laws are probably constitutional in part because federal government can regulate interstate commerce. What about when you're regulating local transactions, right? Someone just walking into a mom and pop shop on the corner. Then you start having to go to the necessary and proper clause, which allows government to regulate local activity. Us Federalists don't like those sorts of arguments, but us Federalists also tend to like liability protection. So I think you're going to have a bit of a divide among people on the right. The Chamber of Commerce is pushing very, very, very hard for this. I don't know if Justice Thomas will go along with it. Now imagine this insanity. Congress enacts a massive preemption bill, and then 5 years later, the Supreme Court declares it unconstitutional. Can you imagine how many lawsuits would be filed retroactively? Like how many suits that were put on hold that would be reanimated? It would be stunning. I mean, I don't know what it would look like, but the amount of litigation over corona is going to be staggering, which is why I think Mitch and the chamber are so eager to have tort protection. Anyone else? Anyone else? Going once, going twice. Ryan, back to you.
All right. With that, we will conclude here. Thank you again, everyone, for joining us, and thank you for the thoughtful questions. I got everyone who answered the trivia questions, so I'll be in contact with you about how to get your book. And I've already gotten some emails, some texts about CLE. Again, please chat me, text me, or email me if you need CLE credit. And one final plug for Professor Blackman's book, Introduction to Constitutional Law.
It's been at the top of the Amazon bestseller for common law for months, so definitely pick up a copy. Thank you.
So, how about a virtual round of applause?
Thank you all so much, and have a wonderful day.
Thank you.